Hello, I'm Anthony Zaller, and this is the California Employment Law Report. Today's video, I want to discuss a recent California Supreme Court decision that impacts the test that employers need to follow in determining whether workers are independent contractors or employees. This decision just came out at the beginning of May 2018, and the case is Dynamex Operations West versus Superior Court. There's 5 key things that I want employers to understand about this ruling. The first item that employers really need to understand is that the test is inherently complex. The court started out its discussion about the determination on how to make the determination if a worker is an independent contractor or an employee. The court said it was just inherently difficult to make this determination, and the factors are oftentimes very gray. So employers need to be cautious about how they classify workers, and especially if they classify workers as independent contractors, they need to be certain that they're doing the classification properly. Now, the California Supreme Court came out with a new test for California employers on how to determine if a worker is an independent contractor or an employee. The test is called the ABC test. They call it the ABC test because there's 3 parts, the A, B, and C parts of the test. Part A, the first factor, is whether the worker is free from the control and direction of the hiring entity in the performance of the work, both under a contract for the performance of the work and actually, in fact, the practice, how the worker is working. Under this Part A of the ABC test, the court discussed some different cases to show employees or workers that were improperly classified as independent contractors. And that, in that discussion, they used one example where truck drivers were required to clean the company truck. They were required to get the company's permission before transporting passengers, and they had to go to the company's center, a dispatch center, to obtain assignments and schedules in advance. The court in that case said that that's not an independent contractor, that's more of an employee. Alternatively, the California Supreme Court in the Dynamex case said that a worker who sets his own schedule, works without supervision, purchases all the materials he uses on his own business credit card, and has declined offer of an employment offered by the hiring entity, that worker was properly classified as an independent contractor under those facts. So that's Part A of the test. Part B is, does the worker perform work that is outside the usual course of the hiring entity's business? So here the courts are really going to look at what your core function of your business is and whether the worker is performing those duties that should fall within the core function. Pretty obvious examples of duties that fall outside of the core function is if you run a retail store and you hire a plumber or an electrician to come in and do work in the business. That's not the core function of the business, and that would be an independent contractor. One example I like to use a lot too is a company hires a lawyer to help perform duties. That's a prime example of an independent contractor doing work that the company normally doesn't do. Alternatively, if a company, the court used an example of the company is a clothing company and they hire seamstresses to work at home, and that normally is done within the company and is a primary function of the company, that's probably going to be more of an employee, probably fall under the employee classification and not an independent contractor classification. Now, the third part of the test, Part C, is whether the worker customarily engages in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. So here the court held that the term independent contractor ordinarily has been understood to refer to an individual who independently has made the decision to go into business for himself or herself. So examples of this are if the worker has insurance, business insurance, they've set up their own business, they advertise independently and promote their services to the public generally, or they've taken all of the steps to get all of the licenses necessary to perform their service as well. Now, the court had also said, as part of this Part C of the ABC test, that the fact that a company does not prohibit or prevent a worker from engaging in business outside of work performed for the hiring entity, that alone does not make the worker somebody that can promote their business outside of that employment relationship or that work relationship. So the worker has to be affirmatively out there doing this, and the fact that they're not prohibited under the contract with the hiring entity is not a determining factor. So employers need to approach Part C cautiously as well. So I've got a link below to an article I wrote about the decision, and if you have any questions, feel free to reach out to me. Thanks.